Okay, welcome to the ICANN76 update. I've got two great panelists with me today. We just had the ICANN event, the ICANN meeting in Cancun, just ended last week. We have Margie Milam, who is the IP enforcement and DNS policy lead at Meta. Margie supervises Meta's domain enforcement litigation program and is an advocate for policy improvements at ICANN that promote internet security. Margie's previous roles include serving as a vice president at ICANN, general counsel at Mark Monitor, and a partner at the law firm of Pillsbury Winthrop, where she specialized in corporate and IP law. Also with us is Mason Cole, who is the internet governance advisor at Perkins Coie. Mason has been in the industry for quite some time and have been involved in internet domain name expansions, issues management, and brand protection for more than 20 years. A recognized leader in internet governance, he serves as chair of ICANN's BC, the business constituency, where he's a vocal proponent of responsible policy development for business users and brand owners. Okay, one quick housekeeping note. We are going. You can submit questions in the Q&A, and then we'll go ahead and answer those at the end of this session. Okay, so let me get started. Here are the topics we'll be discussing today. The domain name registration data who is policy update, now called RDRS. We'll then talk about the NIS2 directive in Europe, the ICANN contract amendments to address DNS abuse, and fourth, we'll be talking about the new round of GTLDs. That's something everybody is waiting to hear about. And then the inflection point at ICANN. I'm going to hand it over now to Mason, who will get us going here.
Thank you, Faisal. Good morning, good afternoon, good evening, everyone. My name is Mason Cole. It's a pleasure to be with you here on the webinar today. And we're going to dive right in with a discussion on what happened at ICANN76 in Cancun last week, specifically as it relates to domain name registration data and the policies surrounding that data, which you may be more familiar with as WHOIS data. If you're not familiar with it, we can ask a basic question, which is what exactly is WHOIS and why is it important? Well, as many of you know, domain name registration data, or WHOIS, is similar to a property record for real estate or your car registration, for example. A WHOIS record tells you who is behind a domain name registration. Now, a WHOIS record can perform any number of functions, one of which is helping brand owners like you identify a source of infringement. It also carries other utilities. For example, security authorities use WHOIS to help, or they try to use WHOIS to track down bad actors in the domain name system. Law enforcement does the same thing. A WHOIS record really can perform any number of functions, and it's a great utility when it is made available. However, as many of you know as well, WHOIS was effectively silenced back in 2018 as a result of the implementation of the GDPR regulation, the European Union's General Data Protection Regulation. GDPR caused WHOIS basically to go dark for the past 5 or 6 years, and making investigatory uses of WHOIS a little bit harder. So brand owners do continue to face challenges when they're trying to track down domain name registration data, particularly when they're fighting infringement. Now, why is this? Because there are 2,000 plus domain name registrars that maintain the data, but there's really no standardized process for making those data requests. You have to go individually to each accredited registrar to ask for the data. ICANN has been working on WHOIS now for literally decades. They continue to struggle to find middle ground that will honor GDPR without over applying the law in the same manner that took WHOIS offline back in 2018. Now, we've had a bit of luck around this in the past, probably about a year or so, with the development of what's called the NIS2 directive. It stands for Network and Information, I believe, Systems. It's a directive that carries the force of binding law that comes out of the European Union. And then we'll talk about this a little bit more later, but the directive instructs the 27 member states of the European Union on what their cybersecurity duties are, and within those duties, what their obligations are around WHOIS. Now, that's the good news. The bad news is registrars, who are the keepers of WHOIS data, domain name registrars, are still reluctant to react to the NIS2 directive and liberalize access to WHOIS. So if you are interested in a WHOIS record and you want to make a request, you must have what's known as a legitimate interest. That means you can't really go to a registrar and say, hey, I feel like having a look at that WHOIS record. Can you give it to me? There has to be a justification of some kind to make that request. Registrars then perform what's known as a balancing test to determine whether or not to disclose. The balancing test means that the need of the data requester has to supersede the privacy rights of the data subject. The data subject in this case being the holder of the domain name. And registrar responses on this vary all the way from disclosing the data to the requester to asking for a subpoena, or some just don't respond at all to a request. Thank you, Fidel. So ICANN, in response to this, was supposed to develop a system called SSAD, which stands for Standardized System for Access and Disclosure. The question is, of course, what happened to that? The proposed SSAD would have been a centralized system for requesting and receiving registration data via one portal. Now, when ICANN started looking into this, they estimated that it would be somewhere between $20 and $27 million to build, and would take about 2 years. And the community reacted negatively to that scenario, and ICANN therefore scrubbed SSAD last year in favor of developing a ticketing system, which we will now discuss. Go ahead, Fidel. So what is this current ticketing system that's being proposed? So the ICANN board approved development of what's called RDRS. I know ICANN is rife with acronyms. That stands for Registration Data Request System. They approved that on February 27th, during a special board meeting. Now, this system will perform really only one function, and that is centralizing requests into one portal. So if you're a brand owner or an investigator of some kind, and you don't want to chase down WHOIS records from each individual registrar, you can go to this portal. It will centralize the request for you and route it to the appropriate registrar, who again then will perform the balancing test and take potential action. The registrar will then follow up with you separately outside the system. So this is a very rudimentary system. It's really only meant to centralize the requests. What kind of timeline do we anticipate? ICANN has said it'll take about 11 months, starting from the December 2022 ramp-up period, to develop and implement the system. But in the meantime, disclosure requests still need to be sent directly to a domain names sponsoring registrar. So what are the potential hazards involved with this proposed RDRS? Well, the biggest one is the fact that it's characterized as a proof of concept system that is really meant to not only centralize the WHOIS requests, but to gauge end user demand in retrieving WHOIS records. There's a concern in the ICANN community that if brand owners and cybersecurity investigators and law enforcement and others who have legitimate interests in WHOIS records don't really use the RDRS, that it can be mischaracterized as a situation where some could say that WHOIS really isn't needed, or there's no real level of registration data demand. And we don't want that situation to happen. It's critical that legitimate interests have access to WHOIS records, and we need to demonstrate that demand. There's also a risk of merely developing a funnel to route the same request to the same registrars with no real guarantee of disclosure. And then another weakness of the system is there's no registry data. Registrar is obviously a retailer of domain names. The registry is the wholesaler of domain names. Both are required to maintain some level of data, but registries are not participating in the RDRS. And so it makes the system over reliant on registrars.
So Mason, it seems like, I mean, the key here is all brand holders should be sending all their notices through this particular system to show that there is a demand for who is. I mean, that's really key.
That's right.
Right?
Yeah, that is a key issue, Faisal. Yes, and it's been discussed extensively at ICANN within the meeting itself that nobody wants a mischaracterization that says, well, if you give up on RDRS because you're not getting fulfillment of the data request, you still should make those requests because it demonstrates the level of demand that there is in the marketplace for WHOIS records.
But I guess one issue that might crop up and a reason why maybe some of these notices aren't being sent out to the registrars is because brand holders are sending enforcement cease and desist to the registrars and then don't ever send the request for the
data itself.
Right. So it almost sounds like what has to happen now is that if two things need to happen. One is a request for the WHOIS information that should be sent directly into that RDRS system, and then at the same time, maybe simultaneously sending that the cease and desist as well, but not to forego trying to get that WHOIS information because at the end of the day, you want to send the cease and desist to the registrant too, right? And if you don't have that information, you can't send it there. So it almost sounds like you have to send it in parallel.
Yeah, it is. You've underscored the point really well that it's been described and is being advanced as a proof of concept system. The RDRS is, and whatever action you take outside the RDRS, it's important to go ahead and back it up with an RDRS request when the system goes live, so that ICANN can see, in fact, that there is quite a bit of demand for WHOIS data out in the end user community.
Got it.
Yeah,
okay,
the other thing that I jump in, sorry, is that there's no requirement that registrars even participate in this portal, this system. So that's one of the drawbacks that was identified last week at ICANN. And there's a request from the ICANN board to the GNSO to at least make that a requirement that registrars have to participate in the system, because right now that's not even clear.
Good point, Margie. So let's finish up on this on the WHOIS policy issue. What are the long-term threats to WHOIS? Well, the longer the data is unavailable, the more that registrars and others could argue that WHOIS itself is antiquated and potentially unnecessary. That's a situation we don't want. ICANN.org itself may continue to argue for continued suspension of various overdue WHOIS related policy work, like the thick WHOIS policy, like data accuracy scoping, like privacy and proxy service accreditation, until access policy is better settled. And those policy initiatives are well overdue and they need to be resolved. And then there's also the risk of conflicting legislation and governmental activity that could cause confusion for registrars, which could prompt them just to take a really conservative approach to disclosure and like they do now, if they don't get uniformity among various governments. Okay, Faisal. Okay, what should brand owners do? Well, as we said, when launched, you need to use the RDRS system to document user demand, regardless of whether or not you eventually receive the registration data. I'd also like to encourage everyone to participate in ICANN77, which is in mid-June. It's in Washington, D.C., so if you're US-based, it's much easier to get to. Brand owners and businesses are actively now being sought after to share their experiences with WHOIS, because there's going to be in Washington an extensive concentration of policymakers around, not only around ICANN itself, but governmental policymakers, and they need to hear from business and IP interests. And if you need to participate and don't know how, the intellectual property constituency is a good place to start. If you're an IP rights holder, if you're a business user of the internet, you're welcome to join or consider joining the business constituency, which is a group that I chair.
So how does that happen, Mason? Do they send you an email? So
Yeah, an email to me would be fine. Or there's also a website, ICANNBC.org, where you can go and get additional information, and you can email our credentials committee with your interest in joining.
Okay.
And the other thing to think about regarding the June meeting is you don't even have to be a member of a constituency to attend an ICANN meeting. ICANN meetings are free. And there are lots of open sessions where you can go, they call it the public forum. There's usually an open mic session where you can go up and share your experiences, even if you're not a member of the IPC or the BC.
Okay, Margie, over to you for NIS2.
So before we go to Margie, just real quick, so what do you have any idea of what the success criteria is going to be for this particular system? What is, will they then turn around and say, yeah, we really think this is working. There's a huge demand for who is. Now we're gonna start focusing on an SAD, or we're gonna build out this. Is there any idea where they're going to go? Because it almost seems like a pilot than anything else.
It's not entirely clear, Faisal, and you're right. It does seem like a pilot where the first step is trying to measure demand for the WHOIS data in the marketplace. And then the tricky part after that will be if they want to build a disclosure function into the system, how to do that without running afoul of GDPR. And that's why the NIS2 directive is so important, because it clarifies some of the duties incumbent on registrars and registries in terms of providing the data. And hopefully that gives us more clarity in terms of how that data can eventually be disclosed.
Got it. Thank you.
All right. So I'm going to give you an overview of this NIS2 directive in Europe and tell you how it applies to the brand enforcement efforts and the WHOIS issues in particular. And the genesis of the NIS2 language came from this directive, Network Information and Security Directive, which was a pre-existing in Europe for many years. And Europe went through a process of updating it. And during this time, we were seeing the difficulties in updating the WHOIS policy to comply with GDPR. So there was this request made to the European Commission that Europe clarify how GDPR applies to the WHOIS database. And so what you see in the Network and Information Security Directive, NIS2, is this new Article 28 that identifies requirements for WHOIS access for the very first time. This has never been legislated in the GTLD space, and mostly from the perspective of the WHOIS information is necessary and essential to prevention and investigations of cybersecurity incidents. So it's very fascinating that although this NIS2 directive has other things that relate to how governments in Europe address cybersecurity threats, there's a particular article that focuses specifically on WHOIS data. It just got adopted in January 16th of this year. And that kicks off a process where it has to be transposed into law in all of the 27 European member states before a specific deadline, which is October 24th. And so that's part of the work that's going to be happening over the next year and a half or so, roughly, to transpose that language into, say, each country's law to make sure that their laws comport with the requirements of the NIS2 directive. And as I'll talk about in a minute, there's it gives very specific information and requirements as it relates to the WHOIS data that will be helpful to enforcement efforts. So essentially, there's this new Article 28. It requires complete and accurate WHOIS information to be collected and maintained by registrars and registries. And that's a big requirement, a new requirement. And the interesting thing about it is it points to some of the issues that we've talked about already as it relates to WHOIS information. For example, the thick WHOIS requirement. Thick WHOIS means that a registry would have all of the contact data for a registrant with respect to the domain name, as opposed to just the technical information. And the NIS2 requirement is that now registries need to be thick. So, for example, .com and .net registries currently do not have the contact information for the domain names, under the NIS2, they would be required to maintain that information. But it's more than that. It actually requires certain information to be publicly available. And this is not just for law enforcement, but this is for everyone. And it's all WHOIS data that is not personal data. So we're talking here about the data of legal persons. And so if you think about, the WHOIS database, it's anyone's guess as to how much of that is legal person's data versus natural person's data, but it should be a fairly significant amount. And so if it's publicly available, you'd be able to query it like you used to in the past, and be able to get it without making these formal requests of citing your legitimate purpose and all of the things that Mason had talked about earlier. It also requires SLAs, very strict response deadline. So 72 hours to respond to an access request and to provide the access for lawful requests. So that's a real benefit as well. You're not going to have to wait 30 days or something to get the data, which helps when you're trying to do investigations, because you should get it in fairly short order. And then there's also a requirement that it would be provided free of charge. And that was in direct response to some registrars that were going through a process where they were actually charging for WHOIS data. So as you can see, this is a bit of a game changer. It clarifies how WHOIS needs to be collected and maintained. A lot about accuracy and verification, which although ICANN to date hasn't really done a lot in this space, there's certainly going to be an impetus to improve the accuracy requirements so that WHOIS information is no longer full of some of the fake data that you may see and may be familiar with. And this essentially would standardize both the public display of information and the ability to access it on request when you have a legitimate purpose. So we're really optimistic about how this is going to impact brand enforcement efforts.
Hey, Margie, I have a quick question.
Sure.
Is there one of the issues that we've seen is if there's no accountability or penalty that attaches to it, then, things just go on. Nobody really doing anything about it. I mean, does the directive have any penalties if registrars don't comply, for example?
As far as I know, it does not, but that doesn't mean that as it gets transposed into member state law, that the states would be able to impose penalties or some sort of fees associated with, if you're not complying. So that's yet to be determined. The way it works with transposition is that the member states have to at least address the issues in the directive, but they can go beyond it and impose other requirements. And so that's why we don't know yet what will happen. But because it is a directive, there are, potential remedies that can, someone can bring a case in Europe as an example, and test some of this, even if there's no specific remedies associated with non-compliance.
And will some of the states come out with their laws earlier than others, or they'll all come out at the same time? How's that work?
They have 21 months, and they can do it right away. We've already are aware that some countries are working on their legislation, or they can wait till the 21st month or anything in between. So that's it's in the state of flux right now. But we do know that the 21-month period is specified in the directive, and that's when all of this will become completely clear.
Got it.
And then there's also a mention of implementation guidelines in the NIS2 directive. So it's possible that some of the member states will cooperate to try to have some sort of harmonization on these requirements. But that's in early stages at this point. And one of the things that we do note is that there could be differences depending upon how how each member state decides to implement this. So it might create additional requirements that aren't even specified in the directive. So what should brand owners do? Certainly, if you're in Europe and this is an issue that's important to you, if you have a lobbying arm or offices in Europe, you might want to talk to your local legislators about how to transpose the who is related provisions into law. The other thing that we can do is, as we were talking about what's happening in ICANN77 in DC, we expect that NIS2 will be extensively discussed. In particular, from the ICANN perspective, the question is how and when will ICANN update the WHOIS policy to address the NIS2 requirements? One of the things that Mason had mentioned earlier was that the reason why there was such difficulty with applying GDPR to WHOIS was that there was a concern about the liability that registrars and registries might have if they did not comply with GDPR. Well, what NIS2 did, it was very express. It actually stated that that its requirements should be deemed to be compliance with legal obligations under the GDPR rules. In other words, it clarified the legal basis for registries and registrars and legitimate access seekers to seek this information. So that kind of clarity should help the ICANN community go back to the WHOIS policy and make it more robust so that it's in line with what NIS2 requires. The other thing is you might want, if you're active in some trade associations, they may be lobbying on NIS2 to try to ensure that the implementation is consistent with what the directive says, and that it reinforces the need for WHOIS access to be available for legitimate access seekers, which include not just cybersecurity investigations, but also any illegal activity under the union law or member state law. So it's a really kind of an important time right now to ensure that we get some solid transposition, and that way the WHOIS can be updated to accommodate the NIS2 directive and be compliant with privacy laws. And as always, the more people that are talking about this and how important WHOIS is, that's what really influences the regulators and ICANN, because ICANN obviously needs to do what it can to ensure that its WHOIS policies support the security and stability of the internet. And the more they hear about it from businesses, the more pressure they have in order to update their policies to accommodate this.
Yep. So Mason, is the BC or maybe even the IPC going to be commenting on any of this? What's the activity from your end?
Yeah, the BC has been active on NIS2 for the past probably, 18 months or so, maybe going on 2 years. We've had some productive discussions with European lawmakers. We'll continue to do that. We also are active in ICANN in persuading the ICANN community to react sooner rather than later on NIS2. There's some reluctance in the community based on what contracted parties, meaning registrars and registries, think about their duties under NIS2. There's maybe some differences in interpretation, but we are working to persuade ICANN as much as we can to deal with NIS2 sooner rather than later, because the harm is not decreasing out there in terms of DNS abuse and other harms perpetrated over the domain name system. So the sooner ICANN can react and react productively to NIS2, the better off everybody in the internet community is going to be. So yes, we're very active on the subject.
All the more reason brand holders should participate and also join the business constituency.
Absolutely. Okay. Back to me for this one, Faisal.
Yep.
Okay. So we'll talk a bit here about domain name system abuse, which we've alluded to already this morning. First of all, what is DNS abuse? Well, DNS obviously stands for domain name system. The definition depends on who you ask. Registrars and registries have tried very hard to narrow DNS abuse to 5 specific types of incidences: malware, phishing, farming, botnets, and spam used as a delivery method for those first 4 types of harm. And we'll talk a little bit about the mechanics of the contract updates in a minute, but I'll say too that other definitions are not so precise. Cybersecurity authorities, even ICANN's own Security and Stability Advisory Committee, has said there's no real suitable definition for DNS abuse, because if you try to narrow it down too far, you won't be able to anticipate emerging threat vectors. So we encourage a broader definition as much as we can. So what's being done about DNS abuse via the ICANN contracts? Well, first of all, what are those contracts? ICANN accredits registrars and registries, which, as I mentioned, are known as contracted parties, and it enters with them into these accreditation contracts, and those contracts spell out expected behaviors. The way that registrars have to interact with their customers, the way registries provision domain names, et cetera. These are all things that are spelled out in the contracts. In the area of DNS abuse, though, the current contracts are very weak. They don't give ICANN's compliance function enough teeth to pursue those who harbor various forms of abuse. So what we've asked for here is the contracts to be updated in a way that establishes not just a duty to investigate and take appropriate action, which is what the current contracts now prescribe, but establishes an affirmative duty for registries and registrars to act on abuse, and to give ICANN compliance the capability to enforce that contract term against registries and registrars who don't do what they're obligated to do under the updated contracts. So what kind of amendments have been requested? Well, over the course of the last 2 to 3 years that we've been talking about DNS abuse, the biggest thing that we've asked for is, again, the affirmative duty to act, not just a duty to investigate. We also would like to see the capability to have registrars act at the account level, meaning rather than chase down offending domain names one by one that may be registered to the same person or the same organization, be able to identify a problem registrant and have the registrar then act across the board against that registrant, and maybe impact all the domain names that registrant has had. That prevents the whack-a-mole problem that we have right now. Potentially include copyright infringement, fraudulent practices, counterfeiting. These are types of harms that are conducted over the DNS that we'd like to see addressed. We'd like to see ICANN conduct a twice-a-year technical or registrars rather conduct a twice-a-year technical analysis to see whether or not the names they sponsor are actually being used to perpetrate security threats, and then report those analyses back out to the community so we know where we stand. Investigate and act within limits of prescribed service level agreements. Report back to the abuse reporter regarding specific actions taken against an abuse complaint. And then again, more robust guidelines to reporters of DNS abuse, mainly educating the community about how to report DNS abuse, what to expect, what timelines are involved in mitigating that abuse, et cetera. Because right now, requests tend to go into a black hole and you don't necessarily hear back from the registrar about what really happened. What's the status of negotiations between ICANN and its contracted parties? It's ongoing. It has been now since around the time of the holidays, and we expect conclusion prior to the mid-June ICANN meeting in Washington, D.C. Go ahead, Faisal. There you go. So what happens after negotiations are concluded? Well, 3 things have to happen. Well, 2 things have to happen. One thing is an additional thing is likely to happen. There will be a public comment period where ICANN will put the contracts out for public comment, the contract amendments out for public comment. And this is we were assured in Cancun that this will be the ICANN community's only opportunity to weigh in on those proposed amendments. So it's very important that you do so when the time comes. Once we get through the public comment period and any changes are made to the language, the contracts will go to contracted parties for ratification, meaning they have to vote to approve the amendments before they enter into force. And then after that, there may be further policy development outside the contract negotiation process where we address additional types of abuse or otherwise establish policy that will help mitigate abuse over the long term.
So I guess, Mason, one key here is to make sure that we, as brand holders, expand the definition to include IP violations as well, right? Is that?
That would be good for a brand holder to have that as an objective. I'll be direct about it. It's a bit of an uphill climb because ICANN is and contracted parties have sort of a standard response to that, which is they don't deal with content on websites, with content management. Our reply to that is there are lots of harms that can happen at the DNS level that still infringe on mark holders' rights. So in Margie's case, it might be, there might be a domain name registered like, metalogin.com. Types of infringement that happen at the DNS level that still need to be dealt with, that are types of harm that aren't contemplated by what the registries and registrars and ICANN are negotiating right now.
Yeah, and this is an important point, that DNS abuse, if it's defined too narrowly, means that this tool might not be as broadly effective as it could be. And the example that Mason gave, if there's a domain name like facebooklogin.com and there's no corresponding phishing site that's up when you send your notice that you can refer to, the response will usually be, well, we don't see abuse, so it will not be taken down. Yet on its face, with the domain string, with those kinds of words, it's pretty obvious that the domain system is being used for malicious purposes. And so that's the kind of examples of where the advocacy work is really trying to expand the definition in a way that can pick up some of those edge cases that shouldn't be a problem because it's pretty obvious that there's malicious intent behind some of those domain names.
Yeah, thanks, Margie. It's a good point. What should brand owners do? Again, you should lodge your public comment when the comment period opens. There will be a public notice on ICANN's website when it does. And then again, you're very encouraged to participate in ICANN77 in June.
And before we jump to the next topic, I just wanted to point out that this is a big development. I mean, the fact that the registrars and the registries are voluntarily entering into the contract negotiations to impose obligations related to DNS abuse really shows that they're taking a look at the levels of abuse that are out there and trying to find a proactive solution for this. In the past, there were these DNS abuse frameworks where some, more responsible registrars and registries would commit to taking things down on a voluntary basis. But I think the industry realized that doesn't pick up the bad actor registrars and registries that maybe aren't as cooperative. And this is an effort to bring up the entire industry so that there's a baseline for mitigation efforts, and that follows years of advocacy. Mason did a great job in highlighting the levels of abuse. Same with Faisal at Tracer, and really pointing out this problem that needed to be addressed. And I think it's important to give credit to the industry, to registrars and registries who initiated these contract negotiations. Obviously, we want it to go further, but that doesn't mean that what they haven't done isn't substantive and something that I think we should really highlight and appreciate.
I agree.
Thanks, Margie. All right, let's talk about new GTLDs quickly. Go ahead to the next slide, Faisal. So what are GTLDs? GTLDs are top-level domains, which is the part that follows the dot in a domain name like .com or .pizza. These are generic terms that meaning they're usually dictionary terms. Sometimes they're branded words. Sometimes they're geographic indicators. What they're not are country code top-level domains like .us for the United States or .jp for Japan, etc. These are generic TLDs. So why is ICANN considering additional TLD expansion? Well, it's been about 10 years since we expanded the namespace in the last significant way. There is belief that there's pent up demand for further specificity in the namespace. ICANN also has a goal to help further participation in GTLD expansion to regions that are economically disadvantaged and also to the global south. Both of those types of areas were not well represented in the last round in terms of applying for new GTLDs. And so there's an opportunity to move ahead with the internet expansion in jurisdictions where maybe there are different languages or there's an opportunity for IDNs, internationalized domain names, or other GTLDs that are specific to those regions. So what's happened so far? Well, we've spent about 2 years taking a look at how actually to facilitate a new round. That process was known as the subsequent procedures policy development. And it's now ready for next steps. So what do I mean by that? I mean that the ICANN board approved 98 community recommendations for the subsequent procedures policy development work. There are more that are unresolved that the ICANN board is still going to look at, but the board has requested a comprehensive implementation plan for a new round, which is basically instructions to ICANN, the organization. The board is saying, okay, ICANN, go and put together a plan for how this new round is going to roll out and be developed. The burning question on everybody's mind is how soon will applications for new GTLDs become available? Nobody knows for sure, but it's not going to be for a while. Our guess is at least 2 years and maybe longer than that. Why is that? Well, ICANN is a bureaucracy and their processes can be cumbersome. There are lots and lots of factors to weigh before a registry can even apply to run a new GTLD. And even once a registry secures a GTLD, it'll probably be a little while after that before you can actually register a name in that TLD. So you're looking at a long-term process here. So what should brand owners do? Again, nothing is immediate, but it's something you should pay attention to, because if you're a brand owner, you're going to need to know things about what types of TLDs could become available. And importantly, what types of rights protection mechanisms are going to accompany that new round. Rights protection mechanisms, or RPMs, as they're known in the industry, accompany every new round as a way to keep intellectual property holders from having to overspend to defend their territory in new TLDs. So you saw RPMs in the last round. You're guaranteed to see them again in the next round. But those are things that you should be aware of and learn about. And then just keep abreast of developments through ICANN into other advocates for rights holders.
So there could be completely new RPMs that come out this particular round, right? That's right.
Yep. Yeah. We don't know what those are going to look like as of yet, but I think you can probably count on either the same types of RPMs plus some new ones, or modifications on previous RPMs as well.
Yeah. Okay, back to you, Margie.
Great. So I wanted to talk a little bit about this concept of an inflection point at ICANN. And a couple things happened last year and this year. But the really interesting thing is, for the very first time, ICANN has appointed women in the 2 most senior roles. So back in October, the chairman of the board, Martin Botterman, was replaced with Tripti Sinha in September. And so it's the first time there's a female chairman of the board. She comes with excellent credentials in cybersecurity and really understands the issues of DNS abuse. So we're really encouraged by that. Secondly, ICANN's CEO, Joran Marby, resigned in December of last year. And Sally Costerton, who's been an ICANN senior executive for some time, she's been at ICANN for a fair amount of time, is now an interim CEO. And the board is now launching a year-long process to search for a new CEO. So we see this as a really interesting time where ICANN can reassess how it re-engages with the community, and we're really excited and hopeful that with the new leadership, we'll see a lot of interesting changes at ICANN. And as we were at the ICANN meeting last week, we really saw that both of these impressive leaders have recognized some of the shortcomings, that perhaps ICANN's processes are too slow or burdensome. Recognize the fact that a lot of business folks have been frustrated about participation and not being heard. And generally, taking a hard look at whether ICANN can become more efficient in implementing some of its policy processes, because as we mentioned earlier, the adoption of NIS2 was a little bit of a wake-up call, in the sense that an area that ICANN could have solved on its own through the policy processes was now being addressed by the European Union, and obviously that's something that I think from an internet governance perspective, ICANN does not want further governmental intrusion on some of these issues, because it creates a possible scenario of conflict of laws, of fragmentation. And so, the better solution really is for ICANN to become more efficient, listen to all stakeholders, and develop policies that touch upon all of the concerns of the community. What we did see, and we were certainly encouraged by this, is there was definitely a more optimistic tone at ICANN. It seemed like there was a really focused talking points and content regarding, how can we produce results? How can we be more effective? Where can we have early wins and deal with some of these issues? And clearly the progress with the negotiations on the DNS abuse is a big deal, and certainly, as I mentioned earlier, is a sign that ICANN wants to get something done, in particular on the DNS abuse issue. And then the advancement of the new round, as Mason had mentioned, there are folks that do want to apply for new GTLDs, and the fact that it's been, a very, very long time, almost a decade since the last one, points to a very ineffective, and slow bureaucratic process. And with someone like Sally, who's currently the interim CEO, with her, strong business credentials, there seems to be a push to try to, speed up the operations and deliver some of these important processes and policies. But the environment right now is a little bit difficult for brand holders. Certainly there's more engagement and interest in brand issues. But as I think you've seen from the theme from these slides, the more participation we can see now from brand holders, especially ones that perhaps were active in the past and kind of stepped away from ICANN. This is really a nice window to re-engage with ICANN and emphasize the importance of having strong, rights protection mechanisms, a solid WHOIS policy, and mitigation requirements as they relate to domain name abuse. And with that, I'll hand it over to Faisal.
So I'm looking on the Q&A. Doesn't appear you guys have done such an incredible job that there are no questions that have come in on the Q&A. So I just want to thank you again, Mason. We'll give people back some time. Thanks, Mason. Thanks, Margie, for your presentation. We really appreciate it. And then hopefully we'll have a similar update after the DC meeting next, 77. Okay.
Thanks for having us, Faisal.
Thanks, Faisal.
Bye-bye.
Thanks, everyone.